Good afternoon, everyone, and welcome to this session of the SIAC China webinar. I'm your moderator, Friven Yo, partner of Sidley Austin, based in Hong Kong and Singapore. We have sign-ups from many locations, I understand, today, but special mention to all the participants dialing in from China. I know that you're still enjoying the last day of your Labor Day holidays. So appreciate your taking time off from your loved ones and family to join us today. Allow me, before we start, to introduce a very esteemed panel of speakers today, very experienced arbitrators and practitioners. Firstly, Professor Lawrence Bu, a member of the SIAC Court of Arbitration, independent arbitrator with arbitration chambers in Singapore. Then we have Ms. Jessica Fay, also a member of the SIAC Court of Arbitration, partner of King & Wood Mallesons, based in Hong Kong and Beijing. And then we also have Mr. Arthur Ma, partner of Dahui Lawyers in Beijing. And last but not least, our very own from Singapore, Mr. William Ong, partner and co-head of litigation and dispute resolution, Allen and Gladhill. Quick logistics announcement. The chat function is disabled for participants, but you're most welcome to post your questions via the Q&A function. And these questions will then be passed on to the panelists, and we'll try and get them answered over the course of this webinar. Or if not, towards the end, we will have a Q&A session as well. So without further ado, getting into the substance. Now, the topic that's set for today is rethinking conflicts of interest in international arbitration. Now, to be clear, in the context of international arbitration, there are a number of ways, as I see it, in which conflicts can arise amongst different participants and stakeholders. But the focus of today's discussions is on how best to ensure that the decision makers, in other words, the arbitrators, and by extension, their decisions are fair and neutral. So for today's purpose, we will leave aside conflicts of interest between other entities, for example, parties and their counsels, and look at the arbitrator and their decision-making process. In international arbitration parlance, we sometimes refer to arbitrators being free from bias or them being impartial and independent. But whatever the term, what we're really concerned is how best to ensure the integrity of the decision-making process, which is manifested, obviously, through what the arbitrators do or not do. So with that in mind, what we want to do today is to consider the roles of different stakeholders towards ensuring the integrity of that process. We will look at, for example, the industry and professional standards, as we know them through the Iba Guidelines on conflicts of interest, for example. We will look at the role of the arbitration institutions, the national courts and national law, as well as the arbitrators themselves. And towards the end, we will also try and look at briefly what sanctions, if any, ought to be imposed on any unethical conduct, and which bodies are most suited for that role. So without further ado, let's start off with the Iba Guidelines. It's fair to say that the Iba Guidelines on conflicts of interest have been widely applied in international arbitration. And arguably even contributed towards the harmonization of how we look at conflicts across different legal traditions. Since its initial iteration in 2004, they have since been updated in 2014 to take into account developing best practices. So perhaps I would ask William to lead us off with a discussion from his perspective. From the practice of his practice, would you say, William, that the guidelines have been an effective tool in providing an objective yardstick against which to measure conflicts of interest. Is there a tension between the IBA guidelines and what the law prescribes? Perhaps we could introduce that topic for us. Thank you.
Thank you, Freeman. Good afternoon, everybody. I'm pleased to meet all of you. My brief today is to introduce the structure of the IBA guidelines, look at how the courts in one or two jurisdictions look at it, and as Freeman says, examine whether or not there's tension between how the court looks at it and how the IBA guidelines deal with certain situations at hand. And from there, we hope we can spur everyone to have a further deeper discussion on the role of the IBA guidelines in this sphere of conflicts of interest. Now, without further ado, the next slide, please. Now, right, so first and foremost, the IBA guidelines, as we all already know, is divided into two parts. It was first promulgated in 2004, and the latest edition is in 2014. Now, we all know that part one of the IBA guidelines deal with the general principles which the body of lawyers, arbitrators, and practitioners who were responsible for the guidelines crafted. And these are general standards regarding impartiality, independence, and disclosure. General principles that provide a good point of reference for arbitrators and practitioners alike, I would say. Part two then goes on to deal with certain application lists of non-exhaustive factual situations. You have the waivable rate list, the non-waivable rate list, the orange list, and the green list. And a lot of times, whilst the factual situations in the list are not exhaustive, one can find examples there that are useful, whether or not they are on all fours with the facts or whether or not they are illustrations of certain principles. Obviously, the IBA guidelines can be stricter in terms of disclosure of relationships than under the common law or the national law of various courts. There are, of course, pros and cons in relation to this so-called stricter approach. Now, obviously, when we talk about the benefits of a stricter approach, it allows parties to consider at a very early stage the disclosures made by the arbitrator. The parties can then examine the situation and explore with the arbitrator as to whether indeed there are any legitimate problems and can make submissions to the arbitrators. And hopefully the idea is that timely disclosures can reduce the number of problems or subsequent changes later on, and hopefully lead to some savings in time and cost. Now, obviously, the perennial problem or concern is that of potential abuse. An arbitrator may err on the side of caution and provide disclosure as a matter of prudence. And one cannot discount the possibility that such a disclosure may lead to more challenges by the parties, even though there may be little merit in the objection. And that is one concern or one potential drawback, if you can call it that way. The next slide, please. Now, we thought, the panel thought that we would flash an example, which is W Limited and M. Sindarin Berhad. It is an English case of recent vintage. Facts are very simple. There was a gentleman, Mr. David Hai QC, who was appointed as sole arbitrator. The parties involved were a party called M. And in the course of the QC or the arbitrator's appointment, the QC's law firm had serviced this entity called Q, which is separate from M, obviously. Now, what happened was that M's parent company actually acquired Q, thus making Q and M sister companies. In other words, the arbitrator is sitting there as an arbitrator. There is a party M before him. There is another entity called Q. And it so happened that in the course of the arbitration, Q and M became sister companies. And the issue was that the law firm where the arbitrator belonged to had done and continued to do a lot of work for Q. And that was the source of a challenge when W, which is the party involved, applied to set aside awards rendered by the QC. The next slide, please. Now, the English High Court dismissed the application on the basis that if you apply the test under the common law, the English common law, which is a reasonable objective test on the part of the third party bystander, whether that person would conclude that there was a real possibility that the tribunal was biased. And it was concluded, obviously, that the tribunal would not be biased for various reasons, one of which was that the fact of the matter was that the arbitrator, even though he was part of the firm, he was for all intents and purposes a sole practitioner within the firm and just using the firm's resources and secretarial support, so to speak. And obviously the second point is that it was only in the course of the arbitration that the two entities involved became sister companies. Now, however, W, the applicant, applied on the basis that, look at paragraph 1.4 of the non-waivable rate list. It is very clear because it says the arbitrator or his or her firm regularly advises the party or an affiliate of the party, and that's in the slide before us now. And the arbitrator or his firm derives much income or significant financial income therefrom. So for all intents and purposes, they say it falls within that paragraph. Next slide, please. Right. Now, I think to be fair, the general standards of the IBA guidelines do make it clear, as one can see from the slide that is before us now, that it has to, when one looks at the various application lists, whether it's red, orange, or green, one looks at the facts of the case. And General Standard 6A does say that, the arbitrator is in principle considered to bear the identity of his or her law firm. Right? However, it goes on to say that when considering the relevance of facts and circumstances, one has to look at the relationship of the arbitrator and so on and so forth. So I think it is fair to say that the IBA guidelines do say that it is a case where you have to look at the facts of each and every case. Can we look at the next slide, please? Now, these are nuanced provisions. However, the applicant relied on the paragraph 2 of part 2 that you can see before us. And words like justifiable doubts necessarily exist as to the arbitrator's impartiality in the situations described in the non-waivable rate list. And non-waivable rate list is the one that I just read out earlier on. So there was that tension, so to speak. And next slide, please. So the IBA guidelines, according to the court at least, the court was of the view that it had failed to take into account whether the particular facts of this case could really have any effect on the impartiality or independence of the arbitrator. And the court found, obviously, that on the facts of that case, the arbitrator concerned did not suffer from any problem where conflicts of interest was concerned. Next slide, please. Now, so one can argue, perhaps, that there are certain categorization or certain lists, and whether or not that is indeed too much mechanistic a process. And what the court said there was that if you look at the situations on the rate list, which was what we are concerned with, and you compare it with the situations in the waivable rate list, such as where the arbitrator has given legal advice on the dispute to a party, arguably situations on the waivable rate list can be potentially worse or more egregious than the one that we are concerned with. And that was one criticism that the court leveled. Next slide, please. Right. So I think on the facts of the English case that we have just covered, it is quite clear that the arbitrator concerned should not have any issues with conflict of interest. And to be fair, in my humble opinion, you will see that the guidelines do make it clear that each case depends on its own facts. Now, very quickly, I'm wary of the time, I will cover a recent Singapore case, VYL and VYN, that is in the Singapore International Commercial Court, a very recent decision in 2020. Now, the facts of that case are summarized at the slide before you, but basically this was an application to set aside an ICC award on the basis of apparent bias. And the argument that was made, there was one argument that was made when it came to bias, and it was that one of the arbitrator, a senior advocate from another jurisdiction, had negotiated and entered into with one of the parties' lawyers in the ICC arbitration a separate brief for some litigation in India. So this was an ICC arbitration. The arbitrator was one amongst three, and the charge was that this particular arbitrator had, whilst the arbitration was ongoing or whilst the award was being drafted, had negotiated with one of the lawyers of the parties, ironically the party who appointed him, a brief to act for another party in some Indian litigation. And the court was quite open to the application of the IBA guidelines and see how that impacts on the test. And the test of reasonableness is as stated in the slide, and it is more or less the same as the English test. Next slide, please. And at the end of the day, the court says that the IBA guidelines are useful. The reasonable suspicion test is to be applied objectively, and the court accepted that the IBA guidelines have achieved widespread acceptance, and it means that arbitrators and the reasonable third-party observer would be aware of the IBA guidelines and the duty of disclosure, and you apply the test of a reasonable suspicion of doubts as to the impartiality or independence of the arbitrator against that context. And that was what the court, SICC court in this 2020 case said. Next slide, please. Right, so generally the Singapore courts very receptive towards the IBA guidelines. Obviously, they are soft law, they are not determinative. At the end of the day, the courts will rely on the principles or the common law tests that we are familiar with and apply them to the facts to decide on issues of apparent bias. Now, next slide, please. Now, obviously, this slide talks about the PRC court's position. I am not an expert on PRC law, but we have experts here, Ms. Jessica Fay and Arthur. They can perhaps talk a little bit about the Chinese court's position. Suffice to say for now that you have Article 34 of the arbitration law of the PRC that talks about when an arbitrator must withdraw from arbitral proceedings. Now, can we move to the next slide? And obviously, you have the Hong Kong court's position, and as far as I can find, they adopt Article 12 of the UNCITRAL model law, which is a system adopted by Singapore as well. Can we move on to the next slide? Right, now, to round off the IBA guidelines discussions, you have the orange list. And the orange list is defined as situations which may, in the eyes of the parties, give rise to doubts as to the arbitrator's impartiality or independence. So it is not an objective test, so to speak, but it is a test which is anchored in the words in the eyes of the parties. And you make the disclosure. And if the arbitrator makes the disclosure, it does not mean that he finds himself or he thinks that he's in a position of conflict. But he makes the disclosure so that the parties can deal with it and object if they want to. And the parties are deemed to have accepted the arbitrator if, after the time concerned, no objections are made pursuant to General Standard 4A. Next slide, please. Now, tribunal secretaries, suffice to say, clearly they are bound by the same rules in relation to conflicts, so I should not say more. And finally, next slide. I end off perhaps with a survey of a case that gripped the attention of practitioners and arbitrators, probably across huge parts of the world. And this arose out of the Gulf of Mexico Deepwater horizon accident. And what happened here was that Halliburton obviously had taken out insurance with their insurer Chubb. And Halliburton was a service provider on the oil rig at the time of the incident. And there was another service provider, which was also the owner of the rig. And that was an entity by the name of Transocean. So what happened was that there was a chairman tribunal, Mr. M, which was appointed by the English High Court after both parties could not agree on the appointment. Now, what happened was that M was therefore the president arbitrator or the chairman of an arbitration between Halliburton and Chubb, right? Now, after M's appointment, he accepted two other appointments as arbitrator in two separate references, which arises from the same Deepwater Horizon accident. And one of them, the appointer, was Chubb as well. So what you have is a situation where you have the two arbitrations or more with the same subject matter, with the same arbitrator, Mr. M, in these two arbitrations, and with one common party. And that common party is Chubb. Right? Chubb in the first arbitration with Halliburton, and Chubb appointed M in the second arbitration where Chubb was involved as well. M did not disclose these appointments to the parties. The parties accepted that there was no bad faith. It simply did not occur to him. And at the end of the day, M wanted to resign if Chubb agreed, but Chubb refused. And H, Halliburton, then applied to the court to have M removed as arbitrator. Last slide, please. So the English Court of Appeal looked at paragraph 3.1.5 of the orange list of the IBA guidelines and agreed that, you know, when an arbitrator serves in a related arbitration involving one party, one of the parties, disclosure is required. But the issue is, what is the effect of non-disclosure? And at the end of the day, when you look at the test, which is the objective test of whether an observer, a third-party observer, would conclude that there was a real possibility of bias by the tribunal, the answer was no. And therefore, the application to remove M as an arbitrator was dismissed. The case went to has gone before the UK Supreme Court. Some of us may have tuned in to the live proceedings when the arguments were traversed. And I suppose I should stop here, having done the survey of the landscape, and leave it to Friven to invite perhaps some of our other panelists to do some crystal ball gazing on what is going to happen later.
Thank you, William, for the very helpful overview on where we are with the IBA guidelines. Certainly, we see some tension here as to certainly with at least with regards to the English law position of reasonable suspicion test, and seemingly what the IBA guidelines provide. So perhaps I know that Professor Bu has some rather strong views on the English law position. So maybe I would invite him to just comment on whether he thinks the English law position is a right test to apply, or is there some other gold standard that ought to that we ought to aspire towards?
Professor Bu.
Professor Bu, Professor Bu, you are on mute at the moment.
I'm sorry, thank you. I was trying to keep quiet earlier. Yeah, thanks. I think William has given a very good overview of what the IBA guidelines is, how it is setting the benchmark for international arbitration. And when I look at the two cases that he has described for us and outlined for us, W and M, Sindiran Bihar and Halliburton and Chubb, I do have some observations to make. Because the first case, W and M, actually was quite critical of the IBA guidelines. And I was quite surprised because, in fact, it was saying that it is an English law decision. But actually, the court went into discussing IBA guidelines on the basis that it says that it is an international arbitration, therefore its decision will have international dimensions, which I think is an overstatement of what the court decision should be. Because basically the IBA guideline sets the duty to make disclosure, minimum disclosures actually, setting out the various scenarios. And in the W&M situation, they criticize it and says that it was wrong in certain, in classifying certain matters as waivable and non-waivable. To the extent that it's actually say that it has got, it should review the IBA guidelines. I think, I'm not sure, in my view is that as a court assessing an English law situation as to whether or not on the reasonable suspicion test, the award should be set aside or the arbitrator removed. It should limit itself to that and not to dissect the IBA guidelines in the manner it did. Because the IBA guidelines is actually a compendium of set up by this group of lawyers representing so many countries that think that this is the minimum standard to be achieved, and which domestic court should have the right to say that it is wrong in doing so. So that's my first comment in relation to W&M. In relation to Halliburton, Halliburton is the court is not critical of the IBA guidelines. In fact, it accepted that it is a standard that one should look at in terms of standard for disclosure. But the Court of Appeal there affirmed the position accepted by the High Court to say that it doesn't matter even if it did not comply with the standard of 3.1.5, so long as no reasonable suspicion or apprehensible bias, the tribunal should not be removed. But forgetting that here again, the very fact that the issue concerns the minimum standard expected of arbitral tribunals, I wonder why the court chose a lower standard. So you have the international standard which sets a higher benchmark in that sense. Why should courts set a lower benchmark? I thought it would be a concern of the courts to ensure that a higher benchmark is met. So both cases gave me a very, I feel a little bit uncomfortable that courts should take that position. And that's why I say I have something to say about it. But I must say that the Halliburton case is, as shared by William earlier, is a little bit more interesting because here it requires the court to make a judgment on even on a orange list issue, 3.1.5. It's an orange list issue. And it attracted the submissions from ICC and LCIA in the Supreme Court hearing. And I hope the Supreme Court will listen to them because they are the voices of an international community representing international arbitration, and it is not a domestic English court issue if they think that is simply a domestic English court issue. And I suspect that if you ask me the question, I think if I may just crystal ball, as William suggested, I think the English court will probably affirm the lower court decision. In other words, they will maintain their position. Because the reason is based on the English attitude so far in terms of development of international arbitration, they have always taken the view that England wants to be different from others. They have refused to accept arbitral model law on the basis that it is intended for more developing legal jurisdictions, and England, of course, do not, in their view, fall within that category, and therefore model law was not adopted. So I think in this, there's some high chance that the Court of Appeal decision will be affirmed, which I hope will not, but I suspect that they will probably do so. That's my view.
Thank you, Professor Bu, for that view. Just a follow-up question. You talked about the higher benchmark, and in Halliburton, I think the court did acknowledge that there was a duty to disclose in those circumstances, even though on the facts they did not amount to a bias or at least a danger of any apparent bias. But if we adopt that higher standard, that higher benchmark, is there a danger of some people would criticize or at least express a concern that we could have a situation of over-disclosure? What is your view on that? Would it actually result in, or is there a concern that may result in more challenges to the point of abuse, as William had mentioned earlier on?
Of course, there is always a suggestion that by setting a higher benchmark, it may attract more challenges. But one must always ask, what is the purpose of obliging an arbitrator to make disclosure? It's part of transparency. It's part of assuring the parties to the arbitration that he is independent and impartial of the parties. If you disclose more and it raises suspicion, it means you're transparent about it and let the parties judge. They can waive it or they can say no, they're uncomfortable, and then the arbitrator should back out or resign and withdraw. So a higher standard is always good. Why should we go for the lowest baseline instead of a higher standard? In fact, in my view, the Iba Guideline is the lowest baseline. And lawyers don't like to be challenged. And though arbitrators don't like to be challenged, I'm as one, don't like to be challenged. So it is always safer to have a higher standard rather than a lower standard. So I don't see a problem of over disclosure. True, it may cause unnecessary disclosure, sometimes can attract unnecessary challenges. But frankly, if any party who is uncomfortable with the arbitrator, if it is possible to resign without doing injustice to the parties, depending on the stage of the proceedings, he should resign and withdraw from the case. I don't see any disadvantage in that.
There was also a counter view, counterbalancing view from a number of other organizations from more sort of specialist fields. For example, in relation to maritime disputes and commodities trading disputes. Is there a concern that where you have these more specialized fields with potentially a smaller pool of arbitrators, and therefore more likelihood of, say, a repeat appointments, like in the case of Halliburton that we've seen? Is this a good reason to adopt a more sort of relaxed approach in those circumstances?
Thank you. For a while, it may be. For a window, it may be possible to grandfather this particular industry or space, say the commodities or oil trading or shipping area. But if it can't go on forever, they must improve. They just got to increase the pool of arbitrators in the area. In the shipping field, for example, it seems to be by the same group of people, at least for those who are based in London. And it has been there like that for a long time. So really, the idea is not to make it anti-competitive, actually. Is to expand the pool so that more people, more arbitrators, younger ones can come in. And instead of saying, oh, now because they are the same pool of people, we should condone the repeat appointments. I don't think so. I think we're going to move on from that. Shipping, for example, has been on, maritime arbitration has been on for years, and we still have not broken out of that circle. Commodities trading is the same. We got to break out of that. And for a short period, maybe a limited number of years to tolerate that, that's good. But I think it's time to break that cartel.
Thank you for those insights. Perhaps we now change gear a little bit. We looked at sort of soft law by way of the IBA guidelines. But what is the role? Is there any role that the arbitral institutions ought to be playing in defining the standards applicable to conflicts? And I know that Jessica, you have had a vast experience working with arbitral institutions, most recently, obviously, as a member of the SIAC court. Could you give us your perspective as to what role arbitration or arbitral institutions such as SIAC ought to be playing in this regard?
Thank you, Freeman. I fully agree that actually the conflicts of interest issue is super important. And I also want to echo Professor Bu's view and opinion. Actually, I think talking from my own personal experience, when I was much younger in the 90s, working with SIAC, and also very long after that, I think I've been supporting the idea of the institutional, at least, for example, an institution like SIAC, to more protect the arbitrator than the parties, in a sense, to protect the stability of the arbitration result, being the arbitral award. I think that's kind of the, probably sometimes people call it pro-arbitration stand by the court. For example, here, English court may think that way is to protect the arbitration results and results. But gradually, and after many years of practice, as counsel and arbitrator, I think I try to think more from the user's perspective. The users are being the parties, you know, that are using international arbitration as for its dispute resolution service. Actually, user's perspective is very important. You don't just want to protect one of the participants of international arbitration and then ignore the views of your users. I think that will be very wrong. In arbitration, we always say the arbitration can only be as good as your arbitrators, which is true. But of course, I think I need to supplement that by, in addition, that you have the right counsel in the beginning. You need to have the right counsel to be able to represent the parties in the first place. And then the next important issue is to pick the right arbitrators for the case. And sometimes, no matter how capable the counsel are, if you have the wrong arbitrator, or to put it simple, being very biased arbitrator, actually, it is really, really hard. You are fighting, you know, multiple fronts, not just your clients and your opposing counsel and also the arbitrator. That would be, I think, a disaster, real disaster. So, you know, conflicts of interest, I think, is very, very important. And that actually, we can, I think in this arbitration practice, we can accommodate and bear the results, even if the result is not so favorable to you or your parties, given every arbitrator is independent and has a fair-minded and try to do their job fairly. But if one of the arbitrators or more is or are biased, then actually it is really hard to argue your case or seek a fair results. So that's actually the last thing the party, being the users to arbitration, would like to have. Of course, sometimes the party who has picked a biased arbitrator who would, you know, favor his case may help them to win. But I don't think that will be the, you know, the ideal world for fair play. And even the winning party will not trust international arbitration through that practice, even if they win, because they pick a biased arbitrator who can, you know, drive the case towards their, you know, favor. I think even the winning party will lose confidence. And of course, if the losing party find this out, they will definitely, you know, be impacted by the experience of this arbitration. And they may then opt to, for example, other dispute resolution methods. So whether the arbitrator can conduct the arbitration fairly and independently is super important. Also, when it comes to disclosure, we have talked about IBA guidelines, and in China, actually, IBA guidelines probably, I think Arthur will comment on this more, are actually only known to a very small number of experienced international arbitration counsel and international arbitrator. And sometimes, you know, people are not so conscious about conflicts of interest issue. And many of these very busy arbitrators in China, they may not have maintained a system or whatever to do conflict check. Because sometimes when institutions approach me for potential arbitrator appointment, I would say, let me run a conflicts check. But some case managers did not understand why you need to do a conflicts check. So, there are issues where people are not paying attention to conflicts. Only the bigger law firms are more, I think, modern law firms in China, I think they have the conflicts check system to be able to run conflicts check properly. Even those, many of those academics who are sitting as arbitrator, do they maintain conflicts information for even if, for example, some may have dozens of appointments during one single year, and do they maintain a real conflicts check database for themselves? I think it is a real question mark here. So of course, the solution would be, people say, what would be the solution? I think institution can play a very, very significant role in making, conflicts of interest a real, important factor for the arbitrators to consider. And they need to be, I think I agree with Professor Bu, the arbitrators, they need to be more disciplined and to make sure that they are being trusted by the parties. And sometimes over-disclosure is better than non-disclosure, because I have seen people who just, who knows if they disclose something, it might be challenged. Although he or she may think, it won't affect my own impartiality or independence, but actually even that is the case, I think it's the call of the parties, whether they would trust you with those elements in mind. So I think that's actually very important to consider the IBA guidelines, at least for reference purpose. And from institutional perspective, I think given the time I have is quite limited, I'll just, before I go to the institutional role in supervising and control the conflicts of interest issue, I want to maybe quickly tell about war stories I had myself. One Stockholm arbitration I had actually, that was actually, I have been in this arbitration circle or practice for some 25 years as counsel, or also for quite long, but actually I have only done one challenge this many years. That was this Stockholm arbitration. The other side appointed a candidate arbitrator and who made a disclosure which was very vague. He disclosed that he was working with the Swedish counsel of the other side for many years and also continued to work with him on something. And that was actually over 10 years time span. So as a claimant's counsel, we were quite concerned of that. So first we didn't decide to challenge him, but then just send a question or ask the potential arbitrator to make disclosure, to give us more details as to what are these kind of connections and works he is having with the opposing counsel. And he refused to disclose any details. And on that basis, we then decided to challenge. And actually that turned out to be, I think, very right decision. We later got much more international and independent tribunal. That also triggered some more war stories. After our successful challenge, that was Stockholm SEC. I think the SEC has adopted very aggressive approach when the case is in its early stage. They would rather opt for removal than keep the arbitrator if there was anything suspicious. That my successful challenge, after that, actually, the other side challenged the arbitrator we appointed and successfully removed one, and the second, just for some of the reasons. And one of these incidents was actually, I was quite upset with. The arbitrator we appointed was a barrister who was actually co-counseled with my then firm at that time. on a Hong Kong High Court case, but actually at the point when we appointed this barrister as arbitrator in this case, that Hong Kong court case was almost concluded. And the arbitrator, the candidate arbitrator, probably had already forgotten about that. So there was no disclosure. And then maybe after my successful challenge of their appointed arbitrator, the respondent side then challenged this arbitrator of my side, of the claimant, and saying, you know, because of that. And then our appointed arbitrator withdrawn. So that's actually, and also triggered, we appointed another one, and that was challenged again. I won't go into further details, but there were a lot of, but after like 6 months, the tribunal was finally constituted, and we had the best tribunal, and then we got whole case on right track. But I think it's all worth it. So that's, I only have time for one war story. So no more war story here. And about the institutional role, I think that's, you know, if you think about the court role we have already discussed, it's very often post-arbitration. You can't do anything after the results is rendered. And of course, most of the, like, you know, arbitration-friendly courts would try to, you know, not to vacate the arbitration decision. So it is very limited remedy post-event. But what institution can do is more than that. At this stage of the appointment, the institution, of course, can try to strengthen the, I think, the measures to make sure that candidate arbitrator can make, you know, full and necessary and reasonable disclosure to make sure that they have that positive obligation than just being, say, generally say, I have no conflicts of interest. I think it might be good to strengthen that by having a specific question list for the potential arbitrator to say yes or no. And then he or she would think about each question they answer, and to make sure they understand and answer the question, you know, either in the positive or negative. And if there is anything they need to disclose as details, they should do so. So I think that's kind of the first kind of control point where candidate arbitrator can do. And also, you know, when the institution is taught to appoint the chairperson, very often in case the parties cannot agree on the presiding arbitrator, the institution will do the appointment. And then at that point, I think, you know, shall also select the chair extremely carefully and try to have conflicts-free chair if at all possible. And also when it comes to challenge, when a challenge is made, I think the institution can play a very important role to make sure, you know, the tribunal will be a fair play tribunal. And sometimes even aggressive, sometimes if the stage is not too late, can consider to be more aggressive in terms of addressing the challenges. And of course, with the secretariat involved, case manager can always help to monitor the function of the full tribunal during the process. And then I think last but not least, the institution can also do more review post-arbitration and ask the secretariat and also ask the parties, the counsel to feedback on their, you know, on the arbitration, their comments. And I think sometimes only post-event parties or counsel can speak up a bit. Because during the arbitration, even if you have challenged, you know, if you fail, then actually sometimes you really feel quite uncomfortable about having the tribunal member that you have challenged, but who's still on. I think given the time, I'll just stop here. Thank you, Freeman.
Thank you, Jessica. I think you certainly touched on a very good sort of essential principle, which is you know, trust in the process and the confidence of the users. And the arbitral institution obviously has a very important role as a gatekeeper in making sure that, at least in relation to the arbitrators' impartiality and independence, that there are sort of sufficient protection to make sure that it doesn't compromise or they do not compromise the integrity of the process. But ultimately, the rules are clear. I think that it is the duty of the arbitrators to ensure that they remain impartial and independent. And it falls on the arbitrators to make the relevant disclosures. So they could be urged, the arbitral institutions have a role in urging the disclosure, but ultimately it is the responsibility of the arbitrators, I think. So I just want to turn to Arthur. I know he's also very experienced as both as arbitrator and counsel, both in China and internationally. So Arthur, from your experience, particularly from a China perspective, do you think there is sufficient guidance as to when an arbitrator can act impartially and independently, or whether disclosure is warranted to let the parties come to an informed decision? What are the sources of reference for you as far as your practice goes?
Thank you very much, Freeman, for the question. First of all, can I confirm that the audience can see my face moving instead of, yeah, because, well, a friend of mine is in the audience and she just texted me and said, Arthur, do you know that it fell into sleep? I confirm I did not. I've been listening throughout. Well, the question you raised, actually, it's not a question I can answer with yes or no. Whenever I talk about arbitration from a China perspective, I always quote the same line which I created myself. I have the copyright. I say 3 ways to do international arbitration: the good way, the bad way, Chinese way. Because you can't really take China as other common law jurisdictions. It's something different, and it's not also it's neither a typical civil law system in terms of arbitration. We have, for example, the 2 tracks, domestic ones, those with foreign elements. So there are some special unique features of Chinese legal system in terms of arbitration in general, and also in terms of conflict of interest issues. For example, I would emphasize, and I think people must understand from outside China, that institutions, arbitration commissions, are playing a critical role in the overall supervision of arbitrators. This is something I found in my experience, many of the international practitioners and arbitrators, they don't understand. Because, for example, we have a panel system, which means for every Chinese arbitration commission, they will have their own panel list of arbitrators. So these arbitrators are listed in a booklet for a fixed term. They sign a contract, they are invited to act as arbitrator, and their name will show on the panel. From that very day, you become a panel member. You are actually supervised by the institution itself. In the slide, William showed at the very beginning that we have the overarching statutory requirement of withdrawal requirements, which is Article 34 of the Chinese Arbitration Act, 1995 or 1994, depending how you count it. That actually is only the broad brush framework for specific situations that an arbitrator must withdraw. It in some aspect is quite similar to the non-waivable red list of the IBA guidelines. So if you fell into those situations, for example, you have personal relationship, it's a blood relative relationship with the parties, or you have a direct interest, financial interest or personal interest in the outcome of the case, that is a non-waivable situation that you must withdraw under the law. But other than that, there is a catch-all provision, which is Section 3, which says other situations. So between the IBA guideline, which is really detailed with detailed situations, and the really broad brush legislation of classic law, what fills in the gap? That is actually the internal rules promulgated by each arbitration commission for their panel arbitrators. Taking, for example, the SIAC. I'm not representing today any institutions in China, but I'm just trying to introduce the internal rules for the conduct of enlisted arbitrators. So SIAC, they have their rules listing all different situations where the arbitrator must disclose upon engagement Some of the situation, for example, if the arbitrator feels necessary that they should disclose personal relationship with the parties, very similar to the orange and green list situations. So these are the gap fillers. And I must emphasize that China is very unique. In some institutions' cases, there are really strict conflict of interest rules, which I think in many other parts are quite difficult to understand. That is, if you are an enlisted arbitrator in that arbitral commission, you simply cannot act in any of the cases before that arbitral commission. That case is the case of Beijing Arbitration Commission. They have very strict rules. Once you are an enlisted arbitrator for BAC, you can never, as long as you're still in your tenure as an arbitrator, you can't take any cases before us. So this is, I think, from any standard, is the most strict rule on Chinese special situation, just to make sure that the parties can appoint impartial and independent arbitrators. So I think the question cannot be answered yes or no. This is the complications I'm trying to let the audience know in China's case. I'll pause here.
Yeah, we certainly understand, I think, some of the tensions and struggles in terms of I think understanding what ought to be a harmonized approach, if there is one, towards the issue. Is this a reason? Would you consider it desirable, though, to have a harmonized set of rules and principles and standards? Is it something that can be achieved?
Well, I
answer, and also I might open up to the rest of the panel to get their perspectives.
May I offer my answer first?
Absolutely, thank you.
Well, from a practitioner's, especially with a background, international background practitioner perspective, I would hope that, for example, the IBA rules can be known to more people, so we would have in the industry practice a rather standard and widely accepted level of communications. So there would not be extreme cases where, for example, I had cases, our appointed arbitrator was challenged simply because he graduated from the same law school 10 years ago from the other side, from one member of my legal team. And I mean, there could be even more extreme cases nowadays. For example, I would imagine some guerrilla tactic would say, well, this arbitrator is biased because he is in the WeChat group of 500 people talking about same issues before. I have the screenshot. These are too far away. We need something that is widely accepted as the industry's best practice. So I would strongly recommend that more practitioners from China to learn about the IBA guidelines.
Would any other panelists like to offer their perspectives?
Well, I think the short point really is that the IBA guidelines is certainly a step in the right direction, because otherwise you could have a challenge in terms of bias at the courts of the seat of the arbitration. You could even have a challenge at the enforcement court of the place where you're seeking to enforce the award on the basis that it is against public policy and whatnot. So obviously, in theory, it is good to have some common standards, and I think the IBA guidelines is certainly a step in the right direction. Whether or not we can take it a step further, that would be the difficult question.
I would say that the IBA guideline is a good starting point, and institutions should not try to come up with their own rules, in my view. In fact, they should participate in the further development of the IBA guidelines, and so that there will be an international or more harmonized standard that we all can look to. Because if every institution and every country want to set up their own, come up with their own rules and on disclosure and conflict of interest, it can be so diverse because we come from different jurisdictions, common law, civil law, and whereas the IBA guideline is actually a fusion of all these concepts, and the lawyers come together and put up this platform and this benchmark. I think it's a good starting point. I would encourage institutions like SIAC, ICC, CTAC to really participate formally in the further formulation of the IBA guidelines. Right now, the individuals who are there are connected to institutions. They're all well-known names, but they are not formally there representing institutions. Perhaps it's time for IBA to open the door and invite institutions to participate.
Thank you for that very helpful insight. We have a few minutes left, and I think we will try and answer some questions. There have been quite a few that have been posted on the Q&A section of Zoom. So we will try and perhaps deal with at least a couple in the remaining time that we have. Something that was mentioned earlier on in relation to the Chinese arbitration law. And one question that we have is the Chinese arbitration law specifies vital personal interest as a requirement to withdraw. Is that a translation issue? What is vital and what is not? Are there any personal interests which are not personal interests in the outcome of a dispute which are not disqualifying? Perhaps we could get Jessica and Arthur to deal with those questions.
Jessica, can I offer the answer? Try to offer the answer, and then you can correct me. Well, first of all, the original Chinese text of Article 34 in Section 2, I mean, the second situation is 与本案有利害关系. So I think to a certain extent, it's a translation issue. To how to translate 利害关系. 利 means in Chinese profit benefits. 害 means damages, detriment. So it doesn't really have the word vital. It doesn't have the word personal. It just said 利害关系. So this is largely a general concept that from my, I'm a native speaker, it can be really broad. What is the benefit? What is the detriment? It can be quite narrow. It can be narrowed down to financial interest, personal interest. So this is a construction of the law issue to me. Plus, there's a translation issue.
Yeah, I agree. I think it's more probably a translation issue. And as Arthur explained, it's probably very hard to find the right wording in English to reflect that. It's actually, of course, it can be explained to include, for example, financial interest or other, important interests that you may have. It's more like in Chinese wording, 利害 is more about interest, but of course it can be minor or significant. And I think the IBA guidelines have defined, for example, the standards to mean in relation to financial interest, it has to be significant financial interest. For example, if the arbitrator's law firm has done some business with one of the parties, but the revenue from that party in the past, recent years is limited and only, it's not very significant. So it doesn't form the issue of interest in that sense. But if a big client, one of the top clients of the firm that contributes, let's say, $10 million per year average, then actually that will definitely constitute significant financial interest. But of course, in Chinese context, I think it also relates to, family relations and other close relationships. So it's probably hard to define here using one word.
Right. Good. Moving on from Chinese law back to the IBA guidelines and perhaps a wider question, I guess, on whether there is a balance between an arbitrator's duty to disclose and the party's duty to investigate. Is there a balance to be drawn here? What role does the IBA guidelines have to play in that regard? Any volunteers?
Well, go ahead, Professor, please.
I won't speak to the IBA guidelines, but I think the obligation of the tribunal or an arbitrator to disclose is not only obligatory under the IBA guidelines, but it's also mandated by law. So in fact, the law obliges us to make disclosure. So it is not something that is negotiable in that sense. So a party may not have a duty as such to investigate, because the duty actually lies with the tribunal to disclose. So, but if the tribunal did not disclose and fails to disclose, and is discovered, facts are discovered by a party who is objecting, then it does look bad, and it puts the arbitrator on the defensive. So that's my observation. So it's always good to disclose.
William?
Well, I echo Professor's words. I think it is quite clear from the case law and all that there is probably no duty to investigate on the part of the parties. But if an arbitrator does not disclose, I think the reasons for his non-disclosure would go into the factoring into the exercise of the court's discretion as to why was disclosure not made. And if it was for a less than satisfactory reason, that certainly would work against the arbitrator in terms of disqualification. So I echo Prof's words. If in doubt, or rather, one should not worry. One should just disclose in case of doubt.
Thank you. I see that we are 6 minutes past the hour, so we are certainly out of time. And thank you everyone who had posed their questions. I think we'll try to find a way, I think, to try and see whether it's possible to have these answered offline. But I do want to thank all the contributions of the panelists for a very interesting and thought-provoking discussions. It does leave us a lot to ponder about. As we've heard, there are no hard and fast solution, but certainly we hope that what we have discussed today will provide a springboard for further forums for discussions and possibly even reforms. So I do want to thank all my panelists for their contribution and their time, and to all the participants today for joining us. Thank you very much.
Thank you, everyone.
Thank you.